Oh, and welcome to today's webinar. We're very glad you could join us. My name is Billy Carson. I'm with University Conference Services. Before we get started, I'd like to give you some general information about this afternoon's presentation. First, we have a very large audience, so we won't be able to open the phone lines for your questions, but you can type them in the questions pane, and that's on the control panel on the right side of your screen. All of your questions are private, so please feel free to ask whatever you like. Our speaker will answer as many questions as time permits at the conclusion of her presentation. Next, if you're listening to the broadcast over your computer and you're having difficulty hearing, dial into the phone number listed in the audio pane in your control panel. We'll also send that number out via chat. Finally, we are recording today's broadcast, and then we'll make this link available via email together with a copy of the presentation. We'll also send out information on HRCI recertification credit. I know that many of you are looking for that, and so I wanted to reassure you that you will be getting that sometime tomorrow. Today's topic, Unraveling DOMA, how the Supreme Court's Windsor decision affects your employee benefit plans, is a topic that's created quite a furor within human resource departments as we try to understand the implications for our benefit plans. We're very fortunate to have as a speaker today someone who can help clarify what actions we should or perhaps should not be taking. Kate Saracene is counsel with the law firm Nixon Peabody LLP. Her primary focus is on helping employers navigate the complexities of the laws governing health and welfare benefit plans. She also counsels employers on qualified retirement plans, non-qualified deferred comp plans, and federal and state labor and employment laws. Kate has represented employers in negotiations with unions and third-party plan administrators, in proceedings before state and federal courts and government agencies, and in labor arbitration hearings. She also has extensive experience in human resources and employee benefit plan administration. Kate well understands the challenges HR and benefits managers face. She spent a significant portion of her career in human resources managing a variety of HR functions for Xerox, including compensation, HR policy, industrial relations, health and welfare benefit plan administration, disability and time off programs, as well as work-life initiatives. She was responsible for benefit plan design and operations, vendor management, ERISA plan documents, summary plan descriptions, associated HR policies, and participant communications. She's also worked in several other HR generalist and specialist roles and has also deep industrial relations experience. I think you'll agree Kate is very well qualified to help us unravel this complex issue. And now I'm going to turn things over to Kate. Kate, I'm going to make you the organizer, and you should have control of the slides now. If you just want to show your screen, you should be good. There you go.
Everything's working, Billy?
It is.
Excellent. Well, welcome, everyone. I've got the agenda up on the screen just to give you an idea of where we're going today. We're going to start out with some background about same-sex marriage in the United States. Then we'll dive into the U.S. v. Windsor decision and talk about what it said and what it didn't say, and also the couple of court cases that have followed since then. We'll talk about the impact on your employee benefit plans and policies, including your welfare benefit plans, FMLA, your non-ERISA benefits, pension 401k, and a couple notes about executive comp. And then we'll give you a to-do list for how you should be responding to the Windsor decision. So starting out with a bit of background about same-sex marriage in the U.S. The first legal same-sex marriage took place in Massachusetts in 2004. Since that time, we now have 13 states and the District of Columbia that permit same-sex marriage. Several of those states are fairly recent. California was as a result of a Supreme Court decision that came out the same day as Windsor. Minnesota and Rhode Island are as recent as August 1st, so just a couple weeks ago have they gone into effect. There are 2 states that have no laws that either ban or legalize same-sex marriage, and those are New Jersey and New Mexico. But the remaining 35 states all have adopted a ban against same-sex marriage. 27 of those are by a constitutional amendment and state law. 3 are by a constitutional amendment only, and 5 are by a state law only. So I've got a map here that shows you how the states line up. The gray states are those that actually perform same-sex marriages. The white states are those that have nothing to say on the issue either way. And the vast majority of those pinkish-orange states are the ones that specifically do not perform or recognize same-sex marriages. There are a handful of states, though, that have civil union laws that provide individuals with the same rights as spouses, but they just don't have the title of spouse. At the time this chart was made, it was Hawaii, Illinois, and New Jersey that allowed civil unions. Colorado now also recognizes civil unions. So let's talk a little bit about DOMA, the Defense of Marriage Act. It was passed in 1996 and signed into law by then-President Bill Clinton. And this occurred at a time before there were any states that would actually perform same-sex marriages as a preemptive measure to pronounce the policy of the United States. And it contained two provisions. The first was that no state would be required to recognize as a marriage a same-sex relationship that was considered a marriage in another state. The other provision was actually a definition that defined marriage as a legal union between one man and one woman for purposes of federal law. The impact of this was that for over 1,000 different federal statutes that confer benefits on spouses, that a same-sex spouse could not be recognized for the purposes of those federal laws. Now, this slide actually shows you what DOMA said. Most federal laws that we're used to dealing with are pages and pages long, but DOMA just had the three provisions: the title, the non-recognition of marriages performed in another state, and then the definition of marriage and spouse. So since that time, we've been having battles in the courts. Proponents of same-sex marriage have been challenging DOMA in courts all over the country. Back in February of 2011, the Obama administration announced their position that they believed DOMA was unconstitutional, and therefore the Department of Justice would not be defending the constitutionality of DOMA in any of these federal cases. Now, there is a provision under U.S. law where the Department of Justice declines to defend a challenged statute. The Supreme Court has held that the legislative branch may, if it wants to, accept the responsibility. And that's what happened here. The House of Representatives commissioned the Bipartisan Legal Advisory Group, or BLAG, and that happened in March of 2011 in order to defend the constitutionality of DOMA. So now let's take a closer look at the Windsor decision itself and the cases that have followed. Edie Windsor and C.S. Spire were a long-term couple. They had been in a same-sex relationship for over 40 years, and they had been engaged for most of those 40 years. And in 2007, they went to Ontario, Canada, where they were married. They lived in New York State, and New York did recognize same-sex marriages performed in Canada. At least as of 2008, there was a formal pronouncement on that. So Thea Spire died in 2009, and she left her entire estate to her wife, Edie Windsor. When Ms. Windsor filled out her estate taxes, she tried to claim the federal estate tax exemption for surviving spouses, but because of Section 3 of DOMA, she wasn't permitted to do that. So she paid $363,000 in estate taxes, and then filed suit seeking a refund. The Internal Revenue Service denied her refund. Windsor then brought suit in federal court, contending that the Defense of Marriage Act violated the Equal Protection Clause of the Fifth Amendment to the Constitution. Now, when she started out in district court, the court found in her favor and said that Section 3 of DOMA was unconstitutional, and it ordered the IRS to give her a tax refund with interest. The IRS did not do that. The case then went to the Second Circuit Court of Appeals, and they again found in favor of Edie Windsor, and the IRS still didn't issue the refund, so it went to the U.S. Supreme Court. So when the case got there, the Supreme Court struck down Section 3 of DOMA. and that's the section that prohibited the federal government from recognizing same-sex marriage for purposes of implementing federal laws. And the court held that DOMA was unconstitutional as a deprivation of the equal liberty that's protected by the Fifth Amendment of the Constitution. And it went through its rationale. One thing they mentioned was that by history and tradition, the definition and regulation of marriage has always belonged to the states. And by seeking to injure the very class of citizens that New York State was trying to protect by allowing same-sex marriage, DOMA violated the basic due process and equal protection principles that apply to the federal government through the Fifth Amendment. The court, here's a quote from the case, it said that the Constitution's guarantee of equality must at the very least mean that a bare congressional desire to harm a politically unpopular group cannot justify the disparate treatment of that group. And when they looked at DOMA's history and the text surrounding its enactment, it found that the interference with the dignity of same-sex marriages was more than just an incidental side effect of DOMA. It was its very essence. So as a result, it found that section of DOMA invalid and held that the federal government has to recognize a same-sex marriage that's recognized at the state level. So looking back at our copy of DOMA again, what they've done is they've stricken Section 3 out of the law. So some people believe that when the Supreme Court ruled in Windsor that DOMA became entirely invalid. That's not the case. They were only ruling on Section 3. And at this point, there has not been a Supreme Court decision as to whether Section 2 is invalid. And that's still open to future challenge. So there are a number of things that the decision did not address. One thing it did not talk about is whether or not states have to permit and perform same-sex marriages. It did not address whether the states have to recognize a same-sex marriage that was performed in another state. It didn't address whether federal recognition of the marriage is based on the state where the marriage was performed or the state where the couple resides. And you'll find through this presentation that that is a very important open question. They did not address whether or not the federal government has to recognize civil unions or domestic partnerships where a state would treat those as the equivalent of a same-sex marriage. Did not address whether employers have to treat same-sex spouses as spouses for purposes of benefit plan design. And it also did not address to what extent the decision has retroactive effect. So we have a lot of open issues for employers to contend with. On the effective date issue, there was some dispute early on about when this decision became effective. There's a provision in the Supreme Court rules that says a decision doesn't become final until 25 days after it's issued. And that's because during the first 25 days, somebody can still petition for a rehearing. So some of the early press on this said that the law was effective as of June 26th. Other people were saying, no, this won't go into effect until July 21. But at this point, we're past both of those dates. So employers are left in a position where now you need to be finding a way to comply with the fact that the same-sex marriage is recognized for purposes of federal law. What we still don't know, though, is whether it has any retroactive effect. Generally, Supreme Court decisions are effective retroactively unless the court says otherwise. But there's a provision in the Internal Revenue Code that gives the IRS the discretion whether or not to make a court decision retroactive for tax purposes, and that's Code Section 7805B. As of right now, and as of an hour ago when I checked the IRS website, they still just have a blurb up there saying that they are reviewing the Supreme Court decision in Windsor. They're working with the Department of Treasury and the Department of Justice to move swiftly to provide revised guidance in the near future. But as of today, we don't have any guidance regarding effective date or retroactivity. The other big open issue that's going to be important for employers is whether or not the marriage is recognized based on the state where the couple resides or the state where the marriage was performed, which everybody's been referring to as the state of celebration. And right now, different federal laws look to the law of different states to determine whether or not a couple is married. So for example, the IRS and Social Security look to the state where the couple resides to determine whether or not somebody's married. But the Defense Department and for immigration laws, you look to the place where the couple was married to determine whether or not they're married, and it's irrelevant where they currently reside. The Obama administration has directed the federal agencies, including the IRS, to issue or modify guidance to implement the Supreme Court's decision in Windsor. We presume it's going to address not only retroactivity, but also this question of residency versus state of celebration. Now, the federal government has come out with at least one pronouncement, and that has to do with how they're handling their own employees. So on July 3rd, the Office of Personnel Management, or OPM, sent a letter to its own benefits administrators and directed them to look at the state where the marriage was performed and to ignore the state of residence when trying to determine whether or not a couple is married for purposes of federal law. There have been rumors that the administration might issue an executive order that will direct the federal agencies that are interpreting the other statutes to look to the place where the marriage was celebrated instead of the place of residence. But as of yet, there has been no such executive order and no guidance changing the rules. So until we get guidance, what we're recommending for private sector and non-federal governmental employers is you should probably look to the state where the couple resides, at least when you're dealing with federal tax purposes, to figure out whether or not they're married, because that has historically been the position of the IRS. Now, there have already been 2 cases that have followed after Windsor, and in those cases, the courts were waiting to hear what the Supreme Court said in Windsor before ruling. The first of those is Obergefell versus Cassis, and that was issued on July 22nd. And this came out of a federal district court in Ohio. And in that case, the court adopted the state of celebration approach. And in that case, they found that Ohio's mini DOMA law likely violated the U.S. Constitution. This was a case about a married couple, John Arthur and James Obergefell. They had been living together for more than 20 years. Arthur was in hospice care and expected to die soon. And the couple traveled to Maryland and entered into a legal same-sex marriage. And in fact, what they did was they had to rent a medical transport plane to fly to Maryland. They never left the runway. The marriage was performed on the plane, on the runway, and then they flew back to hospice. Now, Ohio law specifically refuses to recognize same-sex marriages performed elsewhere. And so what the couple did was they went to federal court in Ohio and sought an order declaring the Ohio law unconstitutional and requiring that when Arthur dies, that the registrar of Ohio death certificates would have to record him as having been married and to record Obergefell as his surviving spouse. So when the court was reviewing this decision, it looked to Ohio law and how it has historically recognized marriages performed in other states. And it found that historically Ohio has recognized a marriage performed outside of Ohio if it was valid where it was performed, where celebrated, including marriages that could not be performed in Ohio, like marriages between first cousins and marriages of minors. The court then found that the Ohio law likely violates the 14th Amendment of the Constitution, which guarantees that no state will make or enforce any law that denies to any person within its jurisdiction equal protection of the laws. The court then ordered the Ohio Registrar of Death Certificates not to accept for recording any death certificate for Arthur that did not record his status as married or didn't record Obergefell as his surviving spouse. The other recent case is that of Cozen O'Connor versus Tobitz. This came out of a federal district court in Pennsylvania. And in that case, the court ruled that spousal death benefits from an employer's profit-sharing plan were payable to the deceased employee's surviving same-sex spouse, not to the parent, even though there was a beneficiary form that named the parent as beneficiary. And the reasoning behind that is because for profit-sharing plans, a beneficiary form is not valid unless it designates your spouse as your beneficiary. And if you want to designate anybody other than your spouse as a beneficiary, you need to have notarized consent of your spouse. And in this case, there was no notarized consent of the same-sex spouse. Now, this case had to do with a couple that was legally married in Toronto, Canada in 2006. They reside in Illinois, which is one of the states that specifically does not recognize same-sex marriage. But what Illinois does is it recognizes a same-sex marriage performed in another state as a civil union for purposes of Illinois law. Now, in this case, the profit-sharing plan document actually specified that wherever federal law didn't answer a question, that the plan would look to the law of Pennsylvania. But the court here ignored that choice of law and said that when you're dealing with an ERISA plan, there's never any use for state law, so the state law is entirely preempted under ERISA. In sum, these early cases are adopting a really liberal approach to recognizing same-sex marriages, but so far the approach is inconsistent. So in Obergefell, you just look simply to whether or not the marriage was valid where performed, because the thought process is that all of these state laws that refuse to recognize the same-sex marriage are unconstitutional. In the Tobitz case, the court didn't have to get that far. They just looked to the state of residence and found that because Illinois would recognize it as a civil union, which has all the same rights as a marriage, that it could recognize the marriage under that theory and never had to reach the question as to whether or not the law was unconstitutional. So that's the background. Now we're going to start to talk about what this means for your employee benefit plans. So, one question you might be asking yourself is, does this mean that I have to extend benefits to same-sex spouses? The first question you have to address there is whether or not your plan is fully insured or self-insured. State insurance laws generally are not preempted by ERISA. So if you are getting insurance in a state that allows same-sex marriage, then usually the insurance policies issued in that state will require that the insurance policy has to cover a same-sex spouse. If you are getting your insurance policy from a state that doesn't recognize same-sex marriage, then you probably need a rider in order to cover a same-sex spouse. Often these are handled with domestic partner riders, and that's how the same-sex spouses are able to get coverage in those other states. So what if your plan is self-insured? Self-insured plans are not subject to state insurance law requirements. So historically, they have not had to comply with these state laws that recognize same-sex marriage or that prohibit discrimination against same-sex couples in terms of employee benefits. Normally this is based on either an explicit exception in the state law itself. A lot of times the state laws will carve out and say, but our rules don't apply to self-funded ERISA plans. Or sometimes this is just done on the basis of the general ERISA preemption principles. Self-insured plans, though, could voluntarily extend benefits to same-sex spouses, such as health benefits for same-sex spouses, but there were tax consequences. So after the Windsor decision, it's less clear whether or not plan sponsors might be exposed to state or federal discrimination claims now that Section 3 of DOMA has been validated. Before, we could always say, well, for federal law purposes, a marriage is between a man and a woman, so our ERISA plan only has to recognize opposite-sex marriages, and, for simplicity's sake, we're just going to say that a spouse is someone of the opposite sex. Not as clear anymore now that that part of DOMA is invalid. So there is no federal law that requires that welfare benefits have to be offered to spouses at all. Even healthcare reform does not require that health benefits are going to have to be offered to spouses. It only requires that you offer coverage to children. So therefore, we have no federal mandate about offering health benefits to spouses, and therefore no federal mandate that you have to offer benefits to same-sex spouses. Well, what happens if you choose to offer benefits to spouses, but you only want to cover opposite-sex spouses and not same-sex spouses? I think that's a more risky game now. Without DOMA there to point to, you have a higher risk of litigation and discrimination allegations. Currently, Title VII of the Civil Rights Act does not prohibit discrimination based on sexual orientation, but that's an evolving area of the law, and things seem to be trending in that direction. There are also state law concerns where you may have a backdoor requirement to recognize same-sex spouses in a self-insured health plan. For example, in New York State, the insurance department has indicated that your stop-loss insurer has to insist that a self-insured health plan covers a same-sex spouse, or else your stop-loss insurer cannot offer you stop-loss coverage. So even if you are self-insured, you need to be aware of these state laws that may impact your decision. Most clients I'm working with have been happy to include the same-sex spouses on coverage and are relieved now to know that some of the tax consequences have been streamlined. But we do still have some clients who have called inquiring whether or not that's a mandate because their companies do not want to adopt that as a policy decision. So let's talk about some of these tax consequences. You know, before Windsor, if you voluntarily offered benefits to same-sex spouses, you had a tax complication. You had to impute income to the employee equal to the fair market value of the same-sex spouse's health benefits. And that wasn't the case if the spouse qualified as the employee's federal tax dependent. But otherwise, if they didn't meet the criteria to be a tax dependent, you had to impute income on the employer's share of the premiums, and then the employee had to pay their share of premiums on an after-tax basis. So that was at the federal level. Now, in the states that recognize same-sex marriage, though, you did not have to do that at the state level. So New York State, for example, said that those benefits would not be taxed at the state level, and that's generally the rule in the states that recognize same-sex marriage. But if the couple was residing in a state that didn't recognize same-sex marriage, then the benefits could be taxable both at the state and federal level. After Windsor, things change. For federal tax purposes, the premiums are going to be tax exempt if the couple resides in a state that recognizes the same-sex marriage. So this is one of the rules that we know for sure and that you should be implementing immediately. If you had been imputing income on the value of benefits, such as health benefits, dental, vision, for same-sex spouses, you should stop doing that wherever the couple resides in a state that recognizes the same-sex marriage. Again, it's not yet clear whether or not you can stop imputing income if the couple resides in a state that does not recognize the marriage. We're expecting the guidance soon. Until we get the guidance, I would stand pat and keep imputing the income until we hear otherwise. For state purposes, in the states that recognize the marriage, the rule is unchanged. You still don't have to tax the employee on the value of the health benefits. Not clear yet what's going to happen in those other states that don't recognize the marriage. Interestingly, most states just adopt the federal tax code for their own tax rules. So some of these states, like Texas, that refuse to recognize a same-sex marriage, if they just look to the federal tax code to determine whether or not something is a taxable expense, it may end up that same-sex benefits won't be taxable in that state if the feds come out with a rule recognizing same-sex marriages based on the state of celebration. So this one is interesting, and we just don't have an answer yet. Now, what if you have been imputing income for several years now on the value of benefits for your same-sex couples? are you going to be able to recover the taxes that were previously paid on that imputed income? And can the employees recover the taxes that were paid since they were paying with after-tax contributions instead of pre-tax contributions? We're still awaiting the IRS guidance, whether or not the application of the law is going to be retroactive. If it is retroactive, though, there's a statute of limitations on tax refunds, which is generally 3 years. So you will likely be able to go back only 3 years and claim your employer FICA tax refund. If the employees can go back and claim refunds for their income taxes, then employers will likely need to reissue some W-2s in order to reflect that those health benefits should not have been taxed. Interestingly, though, if these same-sex couples refile trying to get a tax refund for the health benefits, they might actually end up owing money if they're one of the couples in an income bracket where they would be affected by a marriage penalty. They could end up owing more money than they would recover by filing an amended return. So if it turns out that this is retroactive, we're guessing that employers may be able to file a Form 941X in order to recover the overpayment of the employer share of FICA for the last 3 years. There is a mechanism where employers can also file on behalf of the employee to recover the employee's share of FICA. You have to coordinate that with the employee and get a signed statement from them that they won't be trying to recover that on their own. And for this year, there's still an open question. What do you do about the imputed income that you withheld prior to June 26th? Employers might want to adjust employee withholdings for the rest of 2013 to make up for any over withholdings earlier in the year when you were imputing income. But for now, I would wait and see. I think the IRS will come out with guidance on this soon, and frankly, I'm surprised that we haven't seen it yet. Now, just a note on cafeteria plans and account-based plans. Pre-Windsor, there were some employee benefit plans that, by their very nature, they were creatures of the tax code. And because the tax code would not recognize a same-sex spouse, the employer could not provide benefits under these plans to employees with same-sex spouses to cover the same-sex spouse. So, for example, they could not use cafeteria plans to pay for pre-tax premiums. They could not receive reimbursements from a health flexible spending account for a same-sex spouse's medical expenses. They couldn't receive reimbursements from an HSA, a health savings account, for medical expenses of a same-sex spouse. Same thing with HRAs, the health reimbursement arrangements, and dependent care flexible spending accounts. Post-Windsor, the same-sex spouses are going to be eligible dependents under these plans. So the first thing you need to do is go check your plan documents and your SPDs to figure out whether you have to amend language to make that happen. I have seen some plan documents that contained a definition of spouse as a person of the opposite sex to whom an employee is married. I've seen some plan documents that refer to DOMA for the definition of spouse. And if you have a plan document with language like that, you'll need to amend it now. My question is, what do you amend it to say? What I've been doing with my clients right now, for anybody who needed to do something in the interim, is making a pretty general statement that a spouse is somebody whose marriage is recognized for purposes of federal law. And then we'll let the federal law develop behind that so we can figure out which individuals are married. It's still unclear what you're supposed to do with claims for reimbursements for expenses that were incurred by a same-sex spouse before June 26th. So, for example, if somebody's trying to submit a receipt for a doctor's visit that occurred in March of this year, should your flexible spending account reimburse the expense based on that receipt? We do not have guidance on that yet. I think it's likely that it's going to be fine within the current plan year to reimburse those expenses, but we haven't heard anything yet from the IRS on that either. Now, another thing that happened with the Windsor decision is that it has created a status change event that would permit an election change under a cafeteria plan for pre-tax premium benefits and pre-tax account contributions. So for example, for purposes of paying for premiums for a same-sex spouse's health benefits on a pre-tax basis, enrolling the same-sex spouse or their children as dependents, changing the employee's coverage options, or increasing the flexible spending account contributions, we think that the decision on June 26th was a qualifying election change event that will allow employees to make those changes now. For federal employees, the Office of Personnel Management issued a memo that said they were going to allow 60 days from June 26th for employees to make this type of election changes, and that those election changes would be effective prospectively. Now, some plan documents for cafeteria plans actually specify what length of time employees have after a qualifying event in order to make changes. It's very typical for plans to say that employees only have 30 days following a qualifying event to make an election change. So what you need to do is check your cafeteria plan documents and see how many days you give employees to make an election change. If your plan only allows for 30 days after a qualifying event, and if we treat June 26th as the qualifying event date, then employees have already missed the window. But that doesn't mean that they're out of luck. What you can do is sign an amendment to your cafeteria plan specifying that for this particular event that employees will have a longer period of time. What some of my clients have done is issued a notice to their employees letting them know that there was a qualifying event and giving them 30 days from the date of that notice to make an election change. And then they completed a plan amendment to back that up and allow 30 days from the date of the notice. Now, the fact that these election changes is prospective is just rooted in the normal cafeteria plan rules. Whenever an employee gets married and adds their new spouse to benefits for pre-tax purposes, that should always be done on a prospective basis. So on an ongoing basis, this will continue to be an election change event. For medical plans, it will also be treated as a HIPAA special enrollment right. So whenever an employee gets married to a same-sex spouse and that marriage would be recognized by federal law, the employee will have an election change event to change their cafeteria plan elections. Similarly, divorce from a same-sex spouse will now also be a qualifying event, just like divorce from an opposite-sex spouse has always been a qualifying event under a cafeteria plan. Now, there are a few special rules that you should keep an eye out for when you're administering your account-based plans. There are special rules that apply to spouses, and we're in a unique situation here where we have couples that have been married, at least under some state laws, for a number of years, and suddenly they're being recognized as becoming married on June 26th for federal purposes, and now you have to overlay these spousal limits on same-sex couples that may not have been aware of them before and didn't have to comply with them before. So some of these rules come from the dependent care flexible spending accounts. For example, there's a rule that if a couple is married, they are limited to a combined $5,000 that they can put into a dependent care flexible spending account, and they can allocate the money between the two of them however they want, but together they can't set aside more than $5,000 in these accounts. So it's possible if you had a same-sex couple and both members of the couple are working for you, it's possible that today each of them had elected $5,000 in their dependent care flexible spending account, and you may have to cut back their elections so that together they don't exceed a combined $5,000. There's also a rule that if you have a spouse, that the amount of money you put into your flexible spending account for dependent care purposes can never exceed the amount of your spouse's income. So they would also now become subject to that rule. If they had a same-sex spouse with income that was less than $5,000, they may have to lower their dependent care account contributions. We have similar rules for health savings accounts. For a married couple who has a family plan for high deductible health coverage, they are limited to $6,450 annually for an HSA contribution. Previously, the same-sex spouses were not subject to that limit, but now they are. So if you have them working for you, you want to make sure that their HSA contributions that you're taking through payroll combined don't exceed that limit. And another thing to watch out for is if you have HSAs for your employees and you're putting money into the HSA on behalf of the employee, if they have a spouse who has access to a flexible spending account or an HRA, a health reimbursement arrangement, that disqualifies the employee from having money put into an HSA. So now these same-sex couples who suddenly became married for federal purposes on June 26th are subject to that rule, and they may no longer be eligible for health savings account contributions through the employer if they have a same-sex spouse with FSA or HRA coverage. Another area that is impacted by this is COBRA. So spouses are considered qualified beneficiaries that have special rights to elect health plan continuation coverage following a qualifying event, such as an employee's termination of employment, the death of an employee, or divorce. Before the Windsor decision, employers did not have to extend the spousal rights under the federal COBRA law to same-sex spouses, and it didn't have to provide the same-sex spouses with their own notice of COBRA rights. Now, some employers, and many employers, in fact, voluntarily extended these rights, especially if they were self-insured or if the insurance carrier agreed to it. And in some states, there were actually mini COBRA laws that required that the same-sex spouses receive COBRA continuation coverage, at least under the fully insured medical plans. So now, after Windsor, any employer that's subject to the federal COBRA law, so it's those of you with 20 or more employees, you're going to be required to treat the same-sex spouse as a qualified beneficiary with their own independent right to elect federal COBRA coverage. You're going to have to treat the divorce from a same-sex spouse as a COBRA qualifying event. And you're going to have to mail a same-sex spouse a general COBRA notice, otherwise known as an initial COBRA notice, when they enroll in a plan. And at the time there's a qualifying event, to send them a COBRA election notice. Now, if you have same-sex spouses that have been enrolled in your plan for a long time and they never received a COBRA initial notice, you may want to send those out to them now. There are also some Medicare quirks that are going to be worked out as a result of the Windsor decision. One of them has to do with secondary payer issues. So most health insurance policies are written so that the employer's plan always pays primary, and that applies to active employees and their dependents. But there was a quirk in the law for same-sex spouses. The Medicare secondary payer rules previously allowed the same-sex spouse to have Medicare pay primary, and that's because the federal government did not recognize this person as a spouse. So the employer plans were actually making out on the deal, and Medicare would pay first before the employer's plan whenever you were dealing with a same-sex spouse. That is no longer the case, so you need to make sure that if your third-party administrator was having Medicare pay first, that they stop doing that and that your medical plan will now take over as the primary payer for active employees and their same-sex spouses. There was another quirk that had to do with Medicare creditable coverage. And you may be aware that for Medicare Part B and Part D, there's a rule that an individual has to enroll in Medicare as soon as they become eligible, or else they'll face a premium penalty if they wait and enroll later. And there's an exception that they won't have to pay the penalty if they have creditable employer coverage in the interim. Now for Part B, there was a same-sex quirk again, where they said that the coverage was only creditable if it was due to the individual's own employment or if it was due to their spouse's employment. And because the federal government did not recognize the same-sex marriage, a same-sex spouse was not able to delay enrolling in Medicare Part B, even if they had coverage through their same-sex spouse's employer, because that was not creditable coverage. So what was happening is that these individuals would wait until the employee retired then the employee and the same-sex spouse would try to enroll for Medicare. The employee would not pay a penalty because they had creditable coverage, and the same-sex spouse would suddenly get hit with a large penalty for delaying because they didn't have creditable coverage. So that anomaly is going to go away, and the same-sex spouses will no longer have to enroll in Medicare when they first become eligible if they have creditable coverage through their spouse's employer's plan. Changing gears for a minute, stepping away from ERISA welfare plans, let's talk about Family and Medical Leave Act protections. You're all probably aware that Federal Family Medical Leave Act provides job-protected time off from work for certain events relating to an employee's spouse, such as a serious health condition of the spouse or an injury incurred during military service. The employee can take military caregiver leave to care for a spouse. Or there's also something called qualifying exigency leave related to a spouse's military duty. Now, although the FMLA regulations themselves always referred to state law to figure out whether somebody was a spouse for purposes of FMLA protections, DOMA superseded that and prevented the same-sex spouses from being recognized as a spouse for FMLA purposes. And just a note here, the FMLA regulations specifically point to the state of residence. So some employers wanted to be more generous and give FMLA protections to employees who had same-sex spouses. But this is where we run into the no good deed goes unpunished rule. Because if the employer wanted to be a good guy and give the employee 12 weeks of leave to care for a spouse with a serious health condition, or 26 weeks of leave to care for a spouse who had a military injury, the employer could not count any of that time as part of the employee's annual FMLA entitlement. So even though the employee had already used up their 12 or 26 weeks of leave, if the employee had another qualifying event for a family member that was recognized by the Family Medical Leave Act, the federal law required that the employer give another 12 weeks or 26 weeks of leave time because it couldn't be counted against the employee. So now employers will have a benefit from this. They will be able to count that leave time concurrently. So when you are granting leave for a same-sex spouse, it now counts against the employee's 12 or 26-week allotment. You are mandated now to grant federal family medical leave for same-sex spouses. If you are in a state where previously you were required to give leave time for same-sex spouses, such as California, for example, the good news is that you can now run that leave time concurrently with the federal FMLA. So this may require you to update your family medical leave policies, probably your forms, your letters that go out to employees at the time of leave to make it clear that this does run concurrently. Now, we did get a little bit of new guidance from the feds. This is the first agency I've seen come out with something specific about same-sex couples. Last Friday, the Department of Labor issued new guidance clarifying that same-sex couples are eligible for FMLA. There was a memo to employees that work for the Department of Labor where the Labor Secretary said that the agency had updated numerous guidance documents. They removed all the references to DOMA, and they affirmed in the guidance documents that spousal leave for same-sex couples is permitted. Those guidance documents and the department spokeswoman have confirmed that for FMLA purposes, they are going to look to the law of the state where you reside, and that only same-sex couples that live in the 13 states that recognize same-sex marriages, along with Washington, D.C., currently have FMLA rights. Now, if we look back to those court cases we were considering earlier, the courts may not agree with that position, but that's the Department of Labor's enforcement position for the moment. If you have any benefits that are not ERISA and they're not FMLA benefits, what does this mean for you? So there are plenty of spousal benefits offered to employees through plans that aren't governed by ERISA. Where ERISA doesn't preempt, then you have to follow the law of the state where you're operating. So examples would be bereavement policies, use of sick time to care for a spouse and children, spousal educational assistance benefits, gym memberships where you cover spouses, non-FMLA personal leaves of absence, benefits mandated under state laws. You're going to want to look to the state where the employee is working to figure out whether or not you have to extend those benefits to same-sex spouses. Like the welfare benefit plans, it appears, but it's still not entirely clear, that federal law would permit the employer to discriminate against same-sex spouses. So if you're in a state that doesn't recognize the same-sex marriage, doesn't mandate that you cover same-sex spouses, it appears that that is still okay at a federal level. So now we're going to change gears again. We're going to look at 401k and pension plans. Pre-Windsor, ERISA governed the retirement plans. They were not permitted to extend spousal rights to same-sex spouses because the DOMA definition of marriage governed. Now, there were a few of the special rights for spouses where employers had leeway to treat same-sex couples similarly to how they treated opposite-sex couples. But for many pension plan and 401k plan requirements, these are requirements of the Internal Revenue Code, and therefore the spouses could not be given equal rights with opposite-sex spouses. So now that we've got Windsor behind us, that will permit retirement plans to extend spousal rights to same-sex spouses. Again, here it's unclear whether you're supposed to look at the state of residence or the state of celebration. We anticipate that we're headed toward a state of celebration approach, but until we get the guidance, the conservative approach is to use the state of residence for now when you're making your pension plan decisions. So what are some of these special rights for spouses? Survivor annuities is one example. So if your plan provides annuities, you have to provide a joint and survivor annuity for a same-sex spouse of a retiree, and you have to provide a pre-retirement survivor annuity for the spouse of an employee who dies before retirement. And if the retiree wants to take any other distribution option, you need spousal notarized consent in order to do so. Another special spousal right is that they are the default beneficiary under the plan. So for any plan that doesn't provide annuities, the plan has to have a default rule that a married participant's spouse will be their default beneficiary and that the employee can't designate anybody else without the spouse's notarized consent. There are special rollover rights for spouses so that pension benefits that are inherited by a same-sex spouse can be eligible for rollover to the spouse's own IRA or the spouse's qualified retirement plan. For hardship distributions, you are permitted for purposes of deciding whether there is a hardship to consider the expenses of a spouse, such as a spouse's medical expenses, educational expenses, or funeral expenses, and those can be grounds for hardship distribution. Now you'll be able to consider the expenses of a same-sex spouse. Quadros, the qualified domestic relations orders, will now apply to same-sex spouses, so your plans may have to administer quadros for them where you were not permitted to do so previously. For required minimum distributions, those rules are more liberal if the beneficiary is a participant's spouse, so the same-sex spouses will get that benefit. In some qualified retirement plans, there's a provision that spousal consent is required for a plan loan, so that may now extend to the same-sex spouses. And there are also some attribution rules where a spouse is considered to own employer stock held by the employee for certain purposes, and that will extend to same-sex spouses. So it appears that Windsor not only permits, but actually requires recognition of the same-sex marriage for certain mandatory spousal rights, like the survivor annuities and like the default beneficiary status. There is a possibility that the plan isn't required to recognize the same-sex spouses for some of the optional plan features, like the hardship withdrawals or like the required minimum distribution rules in the event of the employee's death. But discriminating in this way, again, seems risky. It may be okay in the short term, but long term, I think that is probably going to be prohibited. So prospectively, employers need to review their retirement plan language and SPDs to determine if you have to make amendments to comply with Windsor, just like we were talking about with the cafeteria plans and the health reimbursement accounts. You need to look at your definition of spouse and figure out if it needs to be changed now to recognize any spouse recognized by federal law, not just opposite sex spouses. We anticipate there will probably be some guidance that will talk about these amendments and the timing of the amendments. Now that you have to deal with these special rules for same-sex spouses, it's going to be important that you get your employees to report their marital status to you. You should be using the same procedure that you use today for opposite-sex couples. I've had some clients call up and say, well, don't I have to demand a marriage certificate for a same-sex couple that wants to prove they're married? And I said, well, do you do that for opposite-sex couples? And they said, no. Then no, you shouldn't be doing that for same-sex couples. You should be applying the same standards to everyone. We anticipate in the retirement context that your vendors and your record keepers are going to be providing assistance with a lot of these logistical issues. So your best bet is going to be to go back to your record keeper and to ask what their plan is to help you get up to speed with recognizing the same-sex spouses. You know, on a retroactive basis, it's unclear whether or not the same-sex spouses are going to be able to file claims for retroactive benefits. For example, if your employee had died and the same-sex spouse was denied a pre-retirement survivor annuity because they were not recognized as a spouse, might they be coming back now and applying to the plan again for that annuity now that they should be recognized as a spouse? Also unclear whether the same-sex spouses are going to have a valid claim if they didn't give spousal consent for a beneficiary designation and you already distributed the money to somebody else. You know, for example, an employee with a same-sex spouse may want to have the benefits go to their children and not the spouse. At the time that the employee filled out the beneficiary form before they died, there was no requirement to get the same-sex spousal consent. You know, is your plan going to be in jeopardy now for the same-sex spouse coming back and looking for the money? We don't know yet. Office of Personnel Management for the government employees is actually allowing a 2-year window now for the employees to change their distribution elections. And they're going to allow employees to, or retirees, to elect a different form of distribution, including joint and survivor annuities, for example, where that was not permitted previously. Not clear yet whether that's a viable solution in the private sector. There certainly could be some abuse there where people may have retired several years ago and now they have knowledge, such as knowledge of a terminal illness, and they decide that they want to change their election to a joint and survivor annuity. That could end up harming the plans, which will be paying more benefits than it would have under the initial election. So again, I think we should be waiting for guidance before you decide to do anything as generous as OPM is doing for its own employees. For deferred compensation plans, there are many executive comp plans that provide spousal benefits. For SERP, the Supplemental Executive Retirement Plans, there are benefits in the case of unforeseeable emergency distributions where you can take into account emergencies related to the spouse. LTIPs, or long-term incentive plans, often have spousal death benefits. 457B plans have some spousal death benefits and required minimum distribution rules that could be implicated. Stock option plans sometimes have spousal provisions, and other fringe benefits like life insurance that may designate a spouse as the default beneficiary, for example. Now you need to make sure that that's expanding to same-sex spouses. So if you have these plans, you should be digging them out, taking a look at how you're defining spouses, and deciding whether or not you need to make any amendments. So what is your to-do list for responding to Windsor? First thing I'm going to advise everyone is to keep a close watch on the upcoming guidance. A lot of open questions here, such as retroactive effect, whether or not you're going to be able to apply for a FICA tax refund, whether or not you're going to have to issue corrected W-2s if you were imputing income, whether you're supposed to be looking to the state of residence, and some other mandates. Unfortunately, this decision is already in effect, and we just don't have answers to all the questions yet. So as I've been saying throughout, let's implement what we know and hold off on what we don't know yet. You want to dig through all your plan documents, SPDs, policies like your FMLA policy, to determine whether you have to make any amendments to the definition of spouse. Get rid of all the special explanations for same-sex spouses. I used to write a lot of SPDs where we would call out, for example, in the health plan SPD, that if you have a same-sex spouse, your benefits are going to be taxed, and here's how they're going to be taxed. You may be able to clean some of that language out of your documents now, or at least need to clean it up in order to make it accurate. You may need to reprogram your payroll system. If you were on top of things and you were imputing income on same-sex spouse benefits and you were making sure that their premiums were paid on an after-tax basis, now you have to undo all of that to treat them just like an opposite-sex spouse, at least in the states where the marriage would be recognized. Most of my clients who've called about this are proactively reaching out to their employees now to explain the impact of Windsor and to invite employees to disclose their marital status for tax and benefits purposes. So, for example, asking them to fill out a new Form W-4 or notify the pension plan administrator that they have a spouse. If you have domestic partner policies, you're going to want to review those now as well. Think about whether or not they still make sense for you. Many employers adopted domestic partner policies because marriage was not an option for same-sex couples. And then as some states started adopting same-sex marriage, I saw employers holding on to those policies because the same-sex couples still didn't have all the same rights under federal law. So the employer felt that the fair thing to do was to maintain the domestic partner policy. But now you may not have any need for it at all. If you're only operating in states that recognize same-sex marriage, you might want to consider doing away with your policy. On the other hand, if you're operating in the states that don't recognize same-sex marriage, you may need to keep the policy in place as a attraction and retention tool. I suggest that you consider preparing a fact sheet for your employees that communicates what we know about the implications of the Windsor decision. For example, tax withholding. If the marriage is recognized where the employee resides, they should be filling out a new W-4 that indicates that they're married. For welfare plans, here's the list that we talked about. Announce the qualifying event to change elections. Announce that you're not going to be imputing income anymore and that they can pay for premiums on a pre-tax basis. Announce that the same-sex spouses are eligible for HRA, FSA, and HSA benefits. And remind the employees about those special spousal limits that occur for the dependent care accounts and the health savings accounts. For retirement plans, it may be a good idea at this point just to note some of the special spousal rights and to impress upon your employees how important it is that they have those beneficiary forms filled out, and if they're going to designate anybody other than the spouse as beneficiary, that they need to have notarized consent. When an employee gets married, their prior beneficiary form becomes invalid. So with the Windsor decision on June 26th, when they were recognized as being married, I think the likely outcome is that all those beneficiary forms that designated somebody other than the same-sex spouse became invalid. And so same-sex couples are going to need to fill out a new form. With FMLA, again, you're going to want to revise your policies and your letters and notices and let employees know that the same-sex couples are now protected if they reside in a state that recognizes the marriage. For your other benefits, you've got to communicate any policy changes. If you are an educational institution and you offer tuition benefits to spouses, those benefits can now be granted on a pre-tax basis to the same extent they could be to an opposite-sex spouse, so you may want to let them know about that. And then any changes that you're planning for your domestic partner policies. So at this point, we're ready to open it up for questions, and I think Billy's going to help facilitate those for me.
I am indeed, and we have a number of questions here. First of all, if I have employees who were married to a same-sex spouse in New York, but who reside in New Jersey or Pennsylvania, should I recognize the same-sex spouse as a spouse?
So, yeah, this is one of those areas where it's not clear yet. You're going to hear that a lot today. Under that Obergefell case, that case would indicate that New Jersey and Pennsylvania that don't recognize the marriage, well, New Jersey doesn't actually have a law at all on the books. So let's talk about Pennsylvania first. So the Obergefell case would say that the Pennsylvania law is just invalid and that the marriage should be recognized. The Tobit's case was the one that looked at the state of residence and said that where it would recognize a civil union, you should count that. So if you follow the Tobit's case, then in New Jersey, you would recognize the marriage too. But until we get guidance from the IRS adopting a state of celebration standard or specifically saying that civil unions are the same thing as a marriage, I would recommend not recognizing those marriages yet, at least when we're dealing with tax issues, which is mostly what these employee benefit plan issues are. You know, if you get into a pension dispute and you're in one of those states, I think the way to go is to try to work it out amongst the beneficiaries. Or the Tobit's case actually was a pension dispute, and what the plan administrator did was file an interpleader action, which is where the plan administrator goes to the court and says, I have money here and I don't know who to give it to, so I'm going to give it to the court and let the court decide who gets the money. So if you end up in the middle of a pension dispute, that may be the way to go, or take a wait-and-see approach and see how long you can stall until we get some real guidance.
Okay. The next question. My domestic partner policy covers same-sex and opposite-sex domestic partners. Are there differences between taxation of domestic partners and same-sex spouses for health benefits?
Yeah, the answer is yes. You know, what Windsor did was it said that your same-sex spouse will be treated as your spouse for federal tax purposes, just like it would for state tax purposes. Domestic partners are different. So far, we don't have any IRS guidance saying that they would recognize a domestic partner as a spouse for tax purposes. And in fact, there's been guidance saying the opposite. So, you know, at the federal level, these domestic partners are not recognized as spouses. You do have to impute income on their health benefits. You cannot let them use the cafeteria plan for pre-tax benefits, you know, unless they qualify as the employee's federal tax dependent under Code Section 152. At the state level, you know, it depends on the state, but in New York, for example, a same-sex spouse's benefits are not taxed, but a domestic partner's benefits are. There are a small handful of states that have a recognized domestic partnership, and in those states, you might not have to tax the benefits. So this is really a state-by-state analysis. But in general, you won't have to tax for the same-sex spouses, but you will for the domestic partners.
Okay. What are your recommendations if I'm thinking about eliminating my domestic partner policy for health benefits?
The first thing that I would do is look at the states where you're operating. You know, if you are operating in states that don't have same-sex marriage, then I would probably keep the policy because there have not been any real changes yet in the status of the law in those states, and your employees still aren't able to marry, and they still need to cover these individuals on benefits. If all of your employees are in, you know, New England or the handful of other states that have same-sex marriage, you may want to consider getting rid of the policy. But you have to look around at what the competition is doing. You know, domestic partner policies have been around for long enough now that employees have come to expect that they can cover a live-in boyfriend or girlfriend, and that that's part of their benefit package. And if you take it away, and if all the other employers in the area are still offering it, you could have an attraction and retention problem. Another issue that I see a lot with this are domestic partner policies that only covered same-sex domestic partners but not opposite-sex domestic partners. You need to be careful with those, because if you're in a state where the same-sex couple can get married, then there's no rational basis for discriminating in that way. And your policy should either be expanded to also cover your opposite-sex domestic partners, or you should get rid of it entirely, but you shouldn't be leaving it for just the same-sex couples. If you're in a state where they can't get married, though, you still have a rational basis to make that distinction. But if you are going to get rid of this, one thing I see clients doing is giving a lot of advance notice. I had a client who decided to get rid of their policy, and they gave over a year notice. And the thought process there was both to give the domestic partner time to find other coverage and to give the couple time to plan a wedding if that was the path that they were going to go down instead. And if you do have a domestic partner rider on your health insurance policy and you plan to get rid of domestic partner coverage, you have to make sure to notify your insurance company that you're doing that so that they can eliminate the rider on your policy.
Okay. Here we have one for welfare plan change in status. In the state of Florida, since the same-sex marriage is not recognized, we offer domestic partner coverage to same and opposite-sex partners, but we do not permit mid-year changes. Is that appropriate? If not, why?
So if you're in Florida, then you're in a state that does not recognize the marriage. So I think it would be appropriate at this point to continue not allowing the election change event. Cafeteria plan election change events are a list of reasons where an employer may permit a change to be made, and that's optional on the employer's behalf. There are a few of those events, though, that are considered special, and they actually are called the HIPAA special enrollment rights. Marriage is one of those events, but that only applies if your marriage is recognized by federal law. So the state of the land today is that for tax purposes, you look to the law of the state where you reside. The law of Florida would not recognize the marriage, so I don't think that today you would be required to allow an election change event if somebody became married to a same-sex spouse and was in Florida. There are some other election change events, though, you need to watch out for, because if you have a qualifying event on your list that is you've acquired a new dependent, when you say dependent, for that purpose, you look to whether or not somebody is a federal tax code dependent. So theoretically, an employee might be able to make the argument that the same-sex spouse of a domestic partner is their tax code dependent now, and that they've acquired them as a dependent, and therefore they should be able to come onto your plan under that qualifying event reason. So you do need to watch out for that. You know, some employers ask me the question, well, I know I don't have to allow this as a qualifying event, but what if I want to? And then you have to shoehorn it into one of the real reasons. You know, if they're not a tax dependent, then you're doing all this outside the cafeteria plan, so you're allowed to let people on and off the plan sort of at your will. If you have a domestic partner who qualifies, they're not eligible for pre-tax benefits, you can let them on the plan on an after-tax basis, and the qualifying event rules don't matter, so you would have discretion to do that. If they are a tax dependent, though, then you have to fit them into one of the other qualifying reasons, such as acquiring a dependent.
Okay, this is very complicated. We have another situation here. Our company is incorporated in Illinois, but we have employees in Missouri, Wisconsin, and Indiana. Therefore, since Illinois recognizes civil unions, do our SPDs need to recognize this for all employees regardless of the state they're working in?
I'd say the answer is no. You know, in Illinois, somebody is considered married or in a civil union if they, you know, live in Illinois. But if you have employees in other states, Illinois doesn't govern your employee benefit plans. This is ERISA preemption. So as long as you're not a church plan and you're not a government plan, if you're a private sector employer, ERISA governs and the tax code governs your plans. What I've been suggesting for now is that you always look to the state where the employee resides to figure out whether they're married for benefit plan purposes. And in those states that you mentioned, they would not be considered married or in a civil union because those states don't have civil unions.
Okay, here we have one from someone in California. We have registered domestic partners who have gotten married and others that have remained registered domestic partners. Is the employer obligated to treat the registered domestic partners the same as same-sex married partners? I'll repeat that last bit. Is the employer obligated to treat the registered domestic partners as same-sex married partners?
Not yet. So we're waiting to hear. Oftentimes when a state had a domestic partner registry or a civil union process, and then they start recognizing same-sex marriages, the state will pass a law that says everybody who was a registered domestic partner or a civil union partner will automatically become a spouse on a certain date unless they opt out. California hasn't done that yet, as far as I'm aware. So under the current state, you do not have to recognize them and treat them as spouses. But if California passes one of those laws, then you would have to.
Okay, and we have one more. I hope I'm not repeating this one. Married in New York, live in Hawaii, which has a civil union partner but not same-sex marriage. Do we continue to impute income or not for ERISA pre-tax benefits?
I would continue to do it for now. The Office of Personnel Management, when they put out the guidance for their own benefits administration, specifically said that they would not be recognizing civil unions. So that seems to be the current federal government position on this. Now, that Cozen-O'Connor case, on the other hand, one federal court has said, well, gee, yeah, you should recognize it. Even though Hawaii would recognize it as a civil union, that's the same thing as a spouse. But that's just one federal district court up in Pennsylvania. So until we hear something from the IRS, I would continue to impute the income.
Okay. And that answers just about all of the questions that we have. And so I want to thank Kate very much for her expertise today. And I want to thank the audience for logging into today's webinar. We hope to see many of you at our upcoming Las Vegas Mid-Sized Retirement and Healthcare Plan Management Conference. That's in September this year, September 15th through the 18th. And Kate will be a presenter there. She's actually going to do 3 presentations for us, one on DOMA, plus workshops on the Affordable Care Act and the impact of today's environment on collectively bargained health care benefits. So she's going to be very busy. It's going to be an excellent conference. Hope to see you there. As a reminder, you will receive a copy of the slides and a link to the recording via email together with information on HRCI recertification credits. Again, thank you very much for attending today's presentation. Have a great afternoon.